Two families, both had trusts. Both believed they had planned ahead. In one family, by the time the successor trustee realized what was happening, hundreds of thousands of dollars had already been moved. In the other, a husband watched his wife give money away to strangers and had no legal authority to stop it, not because the estate plan was missing, but because it was never activated. These are not unusual cases. They are becoming common, and they raise a critical question. What actually causes an estate plan to fail? Hello, my name is Carla Hartley. I'm the managing partner for Hartley Law Group, a law firm practicing family and estate law in Texas and California. In the last video, we looked at these two families in more detail and how both situations unfolded. In the first family, a relative moved into the parents' home to help. But over time, she didn't just assist. She controlled access. Phone calls were limited, visits became difficult. Eventually, she gained control over the parents' finances. Before the named successor trustee even realized what was happening, hundreds of thousands of dollars had been moved. And by the time the family understood the scope of the problem, the legal fight had already begun. The estate plan existed, but control had shifted outside of it. In the second family, the problem looked completely different. A husband and wife had a trust that had worked for more than 20 years. Their son was named as successor trustee, but the trust required two physicians to certify incapacity before authority could transfer to one party or the other. As the wife's cognitive decline progressed, her behavior changed. She became paranoid, suspicious, convinced her husband was acting against her. By the time he realized that he needed those incapacity declarations from the physicians, she refused to see doctors at all, which meant the legal trigger to give him control of the estate under the trust never activated. This, despite obvious cognitive decline. He had no authority to take control of their finances. Different facts, same result. The estate plan stopped working exactly when it was needed most. And here's what surprises most families. Nothing was missing. The documents were there. So what actually failed? What failed was not the documents. It was the system that controls the levers that allow those documents to take effect. Most estate plans run on three moving parts: the successor trustee, the power of attorney, and the legal determination of incapacity. When those work together, control transfers smoothly. But if even one breaks, the entire structure can collapse, and often does. The successor trustee cannot act. The power of attorney, the holder of the power of attorney, cannot act. And the person experiencing cognitive decline is still legally in control of everything: accounts, assets, even the ability to change the plan. This creates what many estate litigators call the manipulation window. This is exactly what we have seen too many times, but I'm going to stick with the two families that we're discussing. In the first family, that window allowed someone to step in, isolate the parents, get control of the estate plan, and redirect assets. In the second, it left a husband powerless, watching financial decisions he knew were harmful to them being made, but unable to intervene. Different paths, same vulnerability. Elder financial exploitation now costs seniors tens of billions of dollars each year. Many of these cases occur during cognitive decline, inside that manipulation window. Sometimes it's fraud, other times it's influence, built through dependence, isolation, or repeated pressure. The law does provide remedies. Courts can invalidate documents obtained through undue influence. They can reverse transfers. They can impose constructive trusts. But all of that happens after the damage is done, and it requires litigation, which can take years, cost significant resources, and permanently strain families. In more severe cases, families turn to guardianship or conservatorship. At that point, a court decides who controls finances, who makes medical decisions, how assets are managed. But by then, the money may already be gone, relationships are already fractured, and the original plan is already compromised. So the real failure point is not at death when we're talking about estate planning. It's not even at incapacity. It's before incapacity is formally recognized, during early and mid-stage cognitive decline, when judgment is impaired but legal authority is not yet shifted. That is where most estate plans are weakest. So the question becomes, if we know where estate plans fail, how do we design them to work in that window? How do we transfer authority sooner without giving up control too early? How do we prevent manipulation without creating unnecessary conflict? That's what we'll focus on in the next video.